Hello everyone, Surrender Doing here, and I'm super excited on the How's It Going podcast. Today we're featuring Brian Wilson. Hello everyone, Surrender Vaduva here, and we're super excited on the How's It Going podcast. Today we're featuring Brian Wilson, real estate lawyer. He's our go-to guy since we started real estate, so we really respect his opinion. We got some really hard questions. Are you excited, Brian?
I'm excited, Saran, and thanks for having me.
All right, let's rock and roll. All right, guys, we're back. Number 3. This one is huge, okay? Because it's happening a lot. And it happens with a job loss, a death, anything could happen, unfortunately. So if a buyer can't close on time, what are the legal and financial consequences that could come up? This is huge.
Yeah, well,
No pressure.
Of course. Well, Saran, it depends on what the problem is and whether it's a problem that the buyer can fix. So typically, if a buyer can't close on time, 95% of the time it's because their financing has fallen through or is not in order, is not quite ready yet. So there's two scenarios. One is they just need a little bit more time.
Yeah.
In which case they ask for an extension. We'll talk about that in a moment. They're much more serious is their
Like that's the best case scenario.
Yeah, that's the best case scenario. The worst case scenario is their financing has completely fallen through. They've exhausted all other options and they won't be able to close. They won't be able to come up with the money. So what happens then is they default. They have failed to close on time. The seller can then terminate the contract. The seller will then need to minimize their damages, so they'll have to put their house back on the market, put it up for sale, sell it as fast as they can, for as much as they can, and then they can sue that buyer for their damages. So let's say they sell it for a lower price, so it's the difference in price.
Yeah.
There's the carrying cost, because then the person's owning that property for a longer period of time, so there's mortgage interest, there's taxes, there's insurance.
Yeah.
There's all of that other stuff as well, and then obviously there's the deposit that's being held in trust as well, which is typically forfeit when the buyer has defaulted.
Is that forfeited right away, or is that for as an agreement to get out of being charged? Right?
Yeah, well, the deposit typically is held with the real estate agency, so it's stuck in trust.
Yeah.
So it's not automatically going to the seller, so it's stuck there pending some sort of agreement between the seller and the buyer.
Yeah.
Or a court order.
Okay.
So again, when the seller lists their house, sells it, quantifies their damages, then they go back to the buyer and go, see, we've lost this much.
And
then they can negotiate. Then they can negotiate as to what to do with the deposit. In most cases, the whole deposit will be forfeit at minimum. Yeah. The risk for the buyer is that they end up owing the seller a lot more than the deposit. Yeah. If the market has, taken a turn for the worse. And the seller's really lost a bunch of money. Yeah.
Now tell me this though. That's really in the worst case scenario. They'll take the deposit plus extra more damages. I've seen it a lot where people negotiate just the deposit amount and be like, "Hey, let me walk away, keep my deposit, and we're okay." And then that's what I see a lot of, because they know I'd rather go back on the market right away and try to find another buyer instead of going through long-term court and whatnot to try to get the damages, depending how bad it is, I guess. Yeah. Right?
Yeah, and that's a good point, Sarin, but it depends on the amount of the deposit, depends on the parties as well.
Exactly.
And again, if the market's rising, if the seller's going to be able or thinks they're going to be able to sell the house for as much or more, then they're probably more motivated to make a deal with the buyer right away. I would usually, if you don't know that, I would usually counsel my seller client to hold off on making a deal with the buyer until they have a better idea of what their damages are going to be.
And what they're going to sell for, and so prolong it.
Well, if you're not sure, you don't want to make a deal before you know how much you've actually lost.
Damage-wise.
Although, yes, there is certainly a motivation on the seller to sort of end that transaction that's gone sour and free themselves up to sell to somebody else. Yeah. But again, I'd counsel sellers to be careful about making a deal before you know the full extent of your damages.
That's important. This is huge, guys, because we learned a few things here. One, you don't just lose your deposit, or you don't just get the deposit if a buyer defaults. 2, if you're a buyer or a seller and someone does default, you don't just accept the deposit part right away. You need to really assess exactly how much damage you're taking and prolong that agreement with that buyer that's, kind of walking away from your deal. This is huge. I'm really happy we got to answer this. So I think it's going to help a lot of people. Yeah. Thank you very much, guys, for watching this How's It Going podcast featuring Brian Wilson, real estate lawyer here in Ottawa. If you are buying or selling this year, consider Brian Wilson to represent you. My name is Sarin Vaduva from the Ottawa Home Group. Thank you and have a great one.